Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today. Right.
We're starting strong with legal fine print. This is where every word counts. If the defendant was in a hospital instead of a jail, the whole lawfully imprisoned charge could fall apart. It's a perfect example of how location and legal definitions can completely change a case.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, the defendant was located in a hospital, not a confinement by government agency or jail. So I'm requesting that charge is invalid.
That was going to be addressed. That would be addressed at the preliminary examination as to the sufficiency of the matter. So if you're making a motion that I dismiss it at this point, that motion is denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are count Fourth Amendment violations.
Fourth Amendment issues? That's the constitutional shield against unlawful searches and seizures. If the defense proves it, this case could take a major hit. Here's one for you. Should charges be tossed the moment a violation is suspected, or should it play out at trial?
And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge the prosecutor to prove all three.
Would you wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yeah.
What did you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting all the charges are dismissed. Motion for all dismissal on all these charges.
They're not going to be dismissed.
No. Okay.
So, if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point. They're not going to be dismissed on an oral motion.
All papers covered there are got video. A number of agencies were involved in I believe she has obtained all of those videos and those will be sent interdepartmental to jail staff. And I expect it to be interdepartmental tomorrow.
Got it. Okay, so we're not ready. He hasn't got the video. So, Mr. McGill, are you going to have an objection to the adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a...
Here's the clash. He's pushing for a speedy trial, But without full access to the video evidence, it's like stepping into a fight blindfolded. Speed or preparation? Which would you gamble on in his shoes?
Speedy trial. I would like to invoke my right to
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I actually have to leave. So the court follows the normal setting for preliminary examination.
I set it for the 19th, and then he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Magoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, including an eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 2 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 or more than $500 fine plus court costs. Count 4, operating with license suspended, denied, and/or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona, in the city of Milan, Washington County, state of Michigan, that you did a vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge, punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitation programs the court deems necessary. The court could order you to pay the cost of the prosecution, the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. I just asked, do you still wish on representing yourself?
Your Honor, I do, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney?
I would like legal assistance.
What do you mean by that? You like to be represented?
Well, I've called.
Well, we go through this every time. So here's what I'm going to do. I'm going to advise you.
The judge isn't sugarcoating it. Representing yourself is risky. In court, you're judged by the same rules as a lawyer, no matter how many legal clips you've binge-watched online. It's basically walking a legal tightrope with no safety net.
That there are great perils in representing oneself. I told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know court procedure. And that you would be treated the same. Not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. Advise you as to the penalty, charges, and maximum penalties. I will now ask you the question. You may not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. That is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public records.
Thank you, Judge. To your feet, Assistant Public Court Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, so I will set these for preliminary examination.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Tabasco, People versus Bessard, People versus Rosengreen, and procedural unfairness. Sixth Amendment violations, and I do request that the prosecutor provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate, and then the third part of the delay for the prong test is to make sure that there was no undue burden or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that you have due process 14th Amendment rights as well as 8th Amendment rights, and a lot of these are facially invalid. A lot of these charges are facially invalid, and I'm just requesting that the court grant a personal recognizance on my behalf, and for both of these charges, being that we're looking really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, in this bond, and he's requesting a release, Your Honor, PR bond.
A response from the people regarding his bond.
People would have the bond also fail to get the claim. That's how the other I'll wait. There are pleadings filed on bond. And I guess my one remaining point would be you should, with the court's appointment public defender's office, I will make sure that the crucial discovery that I've done is on the defender's office.
Yes.
Correct, the judge. We will review that with our client once we see it.
So, he asked for preliminary examination and realize where this may be. My understanding is that he is still held, regardless of the bond, but in this case, he's being held without bond in the United States. That bond has been denied. So
that's what I would say.
In any event, but also
Here's where it heats up. Escape from lawful custody. The defendant argues, hospital, not jail. The judge counters, still under sheriff's watch. It's a legal tug of war over what defines custody, and whoever wins decides if that charge survives or collapses.
Given the fact that one of the charges is the escape from lawful custody, that in and of itself, this court's mind makes the defendant a danger or a risk of flight. Also, the nature of the charges to killing and looting police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public to the extent that he is asking that I modify his bond condition. Bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence.
I understand the presumption of
Well, and a lot of these are facially invalid.
Excuse me?
A lot of these charges, especially the lawful custody, lawful custody, it's facially invalid. I was at a hospital, not a jail.
You were under the custody of the Washington County Sheriff.
I was not.
I understand.
I was not.
Custody of
I was dropped off at the hospital and later tacked on charges just like the fleeing and eluding charge.
not beat that out, and that if that's true, and the people can't sustain that element, the charge will be dismissed. But I'm not dismissing it on your representation today.
Thank you very much, Judge.
Preliminary examination of this matter will be set August 19, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected.
And here's the twist. The defendant has hit the judge and others in the case with a civil lawsuit. Some see it as a power play, others as defending his rights. But the big question is, can a judge truly stay impartial when the person in front of them is also suing them?
And I will disclose it to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those do not, including many that I don't even know the connection. The court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it put on its face, create a conflict for it. I consider it, quite frankly, frivolous complaint itself. Not see that as necessity for me, myself, and this gentleman's proceedings, because I think that's precisely what he wants to have happen. And if it's happening, he will be dealt with by me as I deal with any of the defendants. And so that is there. It has been turned over to the Office of General Counsel for Washington County. They will meet with, for me, as well as the others that I see that are listed there. They will do that. They have also filed, it appears, and again, this is all part of this, what I will call shenanigans to shake this. He has filed against people, individuals, without specific reference in the Washington County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in this case. So,
filing this file yesterday. At this point, we continue to this case until I do otherwise. We like to prosecute.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some dive that other things.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past, before this complaint. And I do request a change of the venue on that note for both these matters.
Wish to raise change of venue, you may file that in writing, but to the extent you are no motion. Aye.
Thank you very much, Judge.
Bond will continue. Thank you. Swear from the information search warrant affidavit. I will sign these in hand and get right out. Okay, thank you, sir. And, Mr. Brewster?
I'm sorry to judge.
No. You know, I'm just gonna say, sometimes it's just karma, man. Alright. Folks, we're now way off track because of the delay and everything. I've got to give my staff a break, so I'm going to give my staff a break. We will start up as soon as we possibly can. And alright, there. We want to talk.
All right.
I had a case when I was kind of